Welcome back to another jaw-dropping courtroom breakdown. And today, you're about to witness not one, but two legal showdowns. First, a tense battle over mortgage payments and accusations of withheld financial truths. On one side, a man fighting to overturn an ex parte order that he says was based on false or incomplete information. On the other, a woman who insists she only asked for help to keep her head above water, but with the shocking twist that her boyfriend was allegedly living there and contributing financially. And just when you think it's over, the hearing pivots to a completely separate dispute, a spousal support battle that turns on one life-changing detail: remarriage. The judge's decision in both cases will leave you questioning fairness, responsibility, and the very definition of support. Buckle up, you're about to see how truth, timing, and the fine print collide in court.
This is set for hearing today. Mr. Blumberg, you filed a motion. Your client is asking for relief from ex parte order that was signed by the court, requiring him to pay certain household expenses and so forth at the beginning of the case. Anything you wanted to state by way of oral argument in support of your motion today?
Well, I would just again reiterate to the court what my motion and supporting brief suggests, that the court signed an order based on information that was not accurate. I don't know if there were intentional misrepresentations made, but the net effect...
As the attorney for the man begins, notice how he doesn't outright accuse the woman of lying, but instead frames it as omitted facts. That's a subtle but important legal tactic. Directly accusing someone of intentional deception can backfire if you can't prove it. Instead, he plants the seed of doubt. The boyfriend's financial contribution was a material fact that should have been disclosed. In court, omission can be just as damaging as a lie, especially in ex parte situations where the judge is only hearing one side.
Certain obligations, when the reality is that when the motion that was filed, it was asserted that she was not working, and that she failed to indicate to the court that she had her boyfriend living there, a roommate who was contributing financially to the obligations. Those are certainly material facts that were either omitted carelessly or intentionally. The bottom line is that I think that had the facts been properly represented to you, you would not have signed such an order. So we're asking the court at this point to rescind that order. My client has been contributing financially, and he's prepared to continue to do so. But certainly, based on the facts that you were presented, I think that ex parte order was inappropriate.
Mr. Blumberg, are there any temporary orders regarding child support in place? Just looking through the file, you might know off the top.
No, there is not.
Okay. And how much is your client contributing monthly at this point?
Okay, he's paying between $150 and $200 a month.
Okay. All right, Ms. Beeland, what's your side of this?
Here, the woman takes the stand, and she's visibly trying to justify why the $600 mortgage payment was requested. She emphasizes that the mortgage is in both names, framing it as mutual responsibility. Notice how she brings in her low restaurant wages at the time and her current job at Kohl's to show she's trying to be self-sufficient. But then comes the admission: her boyfriend was helping with bills before he left. That's the crux of the other side's argument, and it's now confirmed, though she insists it was only for small expenses.
The reason why we decided for Chauncey to pay $600 worth of mortgage, because it is on his name too, along with mine. And during that time that I'm having a hard time understanding this. The reason why we put this, because I was working at a restaurant, barely making a minimum wage, trying to have fully intent of getting my job that is now, I work full-time at Kohl's, just so he could just help pay the mortgage. That's all I was asking. And my boyfriend, he is no longer in the home, but during that time, he was helping pay all the smaller bills, helping me out with that type of stuff. And up until he recently left, he was paying and helping me pay all of my small bills, and I was paying my mortgage and trying to keep on boat on that. And I have caught up completely on my mortgage so far. It's been hard, but I've been dealing. So I was just asking for help with that. That's all.
All right. Anything in response to that, Mr. Blumberg?
Judge, I don't know that we need to go into the facts why the boyfriend is no longer there. My understanding.
The opposing lawyer subtly drops a bombshell here, revealing that the boyfriend isn't gone because of a simple breakup, but because he was arrested and likely has a no-contact order. While the lawyer claims it's not relevant, mentioning it creates an immediate credibility cloud around the woman's financial situation and judgment. This is Courtroom Strategy 101. Mention something controversial under the guise of dismissing it, knowing it will stick in the judge's mind.
Is he's been arrested and he probably has a no contact provision, but I don't guess that that's really relevant at this point. My client is willing to continue to pay some money to assist, and certainly the kids are with him half the time. So I just, I'm always reluctant when I see these ex parte orders, when facts are presented to the court, and you have no way of knowing whether they're accurate or truthful or not. And I understand it's always best to err on the side of caution, but I genuinely believe that had the facts been properly presented, I don't think you would have signed this order. He'll continue to pay those expenses that he's been paying.
Okay. And Mr. Blumberg, your client is on the mortgage as well, his name?
Yeah. Yes, it is.
All right, so presumably he's got just as much an interest in keeping that mortgage current as Mrs. Phelan does?
Yeah, he does, but he has the expense of another place. Again, when these parties separated, my understanding was that they had an understanding as to how the expenses were going to be shared. That wasn't reflected in any written document, unfortunately.
This moment is key. The judge zeroes in on what the man is willing to pay right now. Why? Because in practical terms, a case like this often comes down to an interim solution, something fair enough to keep the peace until a final decision is reached. The man offers $200 a month, significantly less than the $600 originally ordered. The judge is already leaning toward modifying the order, signaling that the original amount may have been excessive given the circumstances.
But yes, you're right. He has a monetary interest in that property.
Right. Give me just 1 second. I just want to. All right. Is there an amount that we can put on the record here today that your client is willing to contribute per month?
Yeah, my client said he can pay $200 a month.
All right. Okay.
And there it is, the ruling on the first dispute. The judge modifies the ex parte order, locking in the $200 per month payment until further notice. This is a major win for the man, who just reduced his monthly obligation by 2/3. It also shows how quickly a judge can adjust a temporary order when new facts come to light, especially if the original decision was based on incomplete information.
So I think that's fair during the pendency here, given the circumstances. So Mr. Blumberg, the court is going to modify that order and have it reflect that your client is going to pay $200 per month towards the household expenses. So if you can draft an order that will reflect that and submit that to the court, and we'll go forward from there. Ms. Phelan, do you have any questions about that?
No, I appreciate any of the help I can get. So I just appreciate it. Thank you.
Mr. Blumberg, anything further on this file today?
No, Judge, thank you.
Okay, thank you. All parties are free to disconnect at this time. This is set for a motion today, Mr. Van Til.
Without missing a beat, the hearing transitions into a second case, this time about spousal support. The man here is arguing that payments should stop because his ex-wife remarried at the end of 2024. Under most divorce agreements, remarriage is an automatic trigger to end spousal support, but surprisingly, this case doesn't explicitly say that. That's where the legal gray area begins.
You filed a motion to cease spousal support, and your motion's based on the fact that Ms. Van Til remarried at the end of 2024. Is that correct?
Yes.
Okay. Ms. Van Til, is that correct?
Yes,
Okay, are you contesting, the discontinuation of the spousal support?
to an extent, I feel that, I was pretty generous back, in 2021 when, I let him off on over $12,000, in arrearages at the time.
The woman's response here is fascinating. She doesn't deny the remarriage but tries to negotiate. She says she forgave over $122,000 in past due support years ago, implying he owes her some moral debt. Then she offers to cut the payments down to $500 a month for 3 more years. This is a risky move. She's trying to appeal to fairness rather than the strict letter of the law, which may not sway a judge bound by statute.
I'm willing to drop down to $500 a month for, let's say, another 3 years.
Okay, Mr. Van Til, what's your position on that?
No, I disagree.
Okay,
I
all
disagree.
right, well, you know, here's the thing, I reviewed the original judgment of divorce, and it does allow for the court to modify spousal support based on a change in circumstances. Ms. Van Til, and frankly, I'm surprised it doesn't contain the language that if you remarry.
The judge here cuts straight to the legal foundation. The original judgment allows modifications based on a change in circumstances, and remarriage qualifies as exactly that. Even without explicit language, case law and common practice make it clear. When you remarry, your need for spousal support generally ends. The judge also notes that the only factual issue would be whether the remarriage happened. And since that's undisputed, the law is on the man's side.
Typically, once a party remarries, I mean, that's a change in circumstances that warrants the cessation of payment of spousal support. And the whole idea of spousal support is that you don't have the assistance of your marital partner anymore to support you. And when you get remarried, that's no longer the case. So it really, to me, the only fact here that would be a potential issue is whether or not you were actually married, or remarried, I should say. And it sounds like that's not a fact that's in dispute. So for that reason, the court finds that the spousal support should cease. And so, Mr. Van Til, you need to file something with the court that indicates that the court is granting your motion. You can use a form like you used to file your motion in this case, okay?
Okay.
Here's an important procedural nugget. The judge tells the man that even though he's won, the payments won't officially stop until he files a specific order with the court. This is a common pitfall in family law cases. You can have a verbal ruling in your favor, but until it's on paper and signed, your obligations continue. Always follow through on the paperwork.
But that's an important step for you to follow up on, because until I sign that order, I mean, that's what actually stops your obligation for spousal support. So it's important that you submit that as soon as possible to the clerk's office here in Gaylord.
Okay, so it's the form just like the one I sent for this hearing.
Yep, well, you can find the form in the same place. It's gonna be just a blank order. And you're gonna fill in there that the court is granting your motion and spousal support will stop as of February 3rd, okay?
Okay.
Ms. Van Til, did you have any questions about that?
No,
Okay. All right, thank you. That's all for this hearing today.
And just like that, the second case wraps. 2 very different disputes, but both boil down to the same core principle. In family court, circumstances matter, and when they change, so can the orders. The first case hinged on omitted facts about financial help from a third party. The second turned entirely on a life event, remarriage, that legally shifts support obligations. In both, the judge showed flexibility, but also a firm reliance on the facts as they stand today.
Both parties are free to disconnect at this time.
Thank you.
Defendant is not full of money. That is the whole reason we're here. We need spousal support. The spousal support that was awarded previously was inequitable and unfair to defendant, and she is essentially barely getting by having to dip into whatever.
Today's hearings revealed two universal truths about family law. First, the importance of full transparency when seeking financial orders. And second, how certain life changes, like remarriage, can completely alter legal obligations. In the first case, a man successfully reduced his monthly payment from $600 to $200 by exposing missing financial details. In the second, a remarriage ended years of spousal support. Both outcomes were grounded in factual evidence and legal precedent, proving that in court, the truth and the fine print can dramatically shift the outcome. Make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.